speaker is Professor Jennifer Hill. I shouldn't indulge in cliche, but it really is true of Professor Hill that she has forgotten much more about corporations law than I will ever know. She is the inaugural Bob Baxt AO Professor of Corporate Law and Commercial Law at Monash University, Faculty of Law, and a Director of the Centre for Commercial Law and Regulatory Studies. She writes in the area of comparative corporate governance, and consistently with that international focus, she has held visiting, research and teaching positions at Cambridge University, Cornell, Duke, NYU, the University of Virginia, Vanderbilt universities. She's a research member of the European Corporate Governance Institute, a life member of Clare Hall, Cambridge, and a life member of the Australian Corporate Law Teachers Association. She is a graduate of the University of Sydney and Oxford Universities, and I cannot think of anyone better to hear next on the topic we've got tonight. Professor.
Thanks so much, John, and for that kind introduction as well. So it's my great pleasure, everyone, to be on this call and to be on this panel. And what I'd like to do in the time that I have available today is to try to put some of the key messages that I think came out of the Banking Royal Commission and also that have come out of the discussion that we've been having on the panel so far, to try to put those messages into a broad historical and international context. And I want to focus just on individual liability of directors. I'm not sure, we might have some time at the end to talk about corporate liability versus individual liability, but I'm going to focus on individual director liability. And I want to discuss what I see as two quite important shifts that are going on at an international level. Firstly, in relation to the role of company directors and the changing societal expectations of directors. And then following on from that, I want to talk about different enforcement systems and patterns of directors' duty enforcement internationally. So let me start then with this, I think, real shift in how company directors are viewed in terms of their role within the corporation and these changing societal expectations of directors. Dr. Higgins started her presentation talking about a quotation from Justice Middleton from Asic and Healy. And I think that quotation really reflects the modern view we have of company directors and particularly the shift to independent directors. And that is that these directors are monitors of what's going on in the corporation. And that idea of company directors as being monitors is several decades old. It really comes from the 1960s, I think, in the US and the work of very famous US professor Melvin Eisenberg at Berkeley. And he wrote in the 60s and 70s saying, company directors are treated in the case law and in the literature as if they run corporations, and they don't. They monitor what is going on at the executive level. And of course, we now see this idea of majority independent directors. It's swept the world, it's all through Asia, and of course, it's also in the ASX corporate governance principles and recommendations. However, at the same time that Professor Melvin Eisenberg was writing, there was another famous doyen of US corporate law, Professor Victor Brudney, who said, well, it's one thing to say that directors are monitors, but what are they supposed to be monitoring? And Professor Brudney thought that the whole concept of directors as monitors was quite ambiguous. And he thought that there were at least three things that these directors could be monitoring. And the first was corporate integrity. The second was financial performance and efficiency. And the third was corporate social responsibility. Now, ever since the law and economics school of corporate law swept the world in the 1980s, we have tended to focus on the second of those two monitoring roles, financial performance and efficiency. And indeed, every now and then, scholars will, it happened a few years ago, 2 or 3 years ago, Professor Peter Swan from University of New South Wales really doubted the benefit of independent directors in public companies because he said, well, their performance hasn't improved as a result of having independent directors on the boards. And so that is a real reflection, I think, of the strength and the dominance of this idea of efficiency and financial performance as being the raison d'etre for having independent directors. However, the Banking Royal Commission and the 2018 APRA report showed us that there's a whole range of other problems in the financial sector. And it wasn't just about financial performance and efficiency, because those banks were doing fabulously well financially. And the real problem in both those influential reports was seen to be the fact that there were perverse incentives in the structure of the organisations themselves. There were flawed corporate cultures which were damaging to organisational integrity. And indeed, the APRA report in 2018 viewed the ongoing financial success of the Commonwealth Bank as being part of the problem. That report said that the fabulous financial performance of the bank had dulled the senses of senior management and the directors to the dangers that were posed by non-financial risks, such as money laundering and counter-terrorism rules. So in the Financial Services Royal Commission final report, Commissioner Hayne very clearly laid blame for the misconduct that had occurred at the feet of the organisations themselves and their directors and officers. And we've seen these, those were financial problems where the customers were harmed. We've seen different types of scandals since that time in Australia, but which raise parallel issues. And I'm thinking here of the sexual harassment scandal at AMP, the Duke and Gorge scandal at Rio Tinto. And these raised issues of organisational integrity and the extent to which it could be said that the board should have, known what was going on. And so I think that these various scandals show us that it's not sufficient for boards in performing their monitoring role simply to assure themselves that everything is going well from a financial perspective in the company. Boards do increasingly need to focus on how the company is making their money and whether the financial success is attributable to unethical means or harming other stakeholders. So that's the Australian context, which I think, was really a very big deal coming out of the Banking Royal Commission and has changed the zeitgeist, I think, in Australia. What about internationally? Well, I discussed just 4 international developments that I think run along these lines that it's interesting to note. Firstly, in the UK, Professor Colin Mayer from Oxford University is a financial economist, and here's the impetus behind a very influential current British Academy project called The Future of the Corporation. And that project is designed to better align the actions of business with the needs of society. And the project defines the whole purpose of its business in the following terms. And obviously, the purpose of business is closely tied to the role of company directors. And they say that the purpose of business going forward in the 21st century should be profitably solving the problems of people and planet and not profiting from creating problems. And of course, profiting from creating problems was part of the issue in the Banking Royal Commission. Secondly, in Europe at the moment, there are some interesting moves afoot. So in July 2020, the European Commission published a study which was done by Ernst & Young at its direction on directors' duties and sustainable corporate governance. And this study has received considerable attention because it is expected that the European Commission will act on it and introduce reforms in the second quarter of 2021. And for those who may be interested, there was a conference on this report that was held by the European Corporate Governance Institute in November last year, which you can watch online if this report is of interest. But a central problem that was identified by Ernst & Young in that report was the belief that many EU companies have an undesirably short-termist approach in which they, and the report blamed this on a narrow interpretation of directors' duties and the tendency to favour short-term profit maximisation over other values. Now, one of the reform options that has been put forward in that Ernst & Young report is the possibility that directors' duties should be taken out of the realm of being seen as for the benefit of shareholders, and that there should be introduced a provision similar to the statutory provision in the UK under Section 172 of the UK Companies Act 2006. And that is a provision that was introduced in the wake of the Enron and WorldCom scandals. It came a little later than our reforms in Australia or the US reforms in Sarbanes-Oxley. But the UK reforms introduced for the first time statutory directors' duties, and a lot of attention has gone to this provision, Section 172 of the UK Act, which said that directors must promote, quote, the success of the company for the benefit of its members. But in doing so, the directors must consider the interests of a wide range of stakeholders and a wide range of factors, including the interests of the community and the environment. Now, the EU proposed reforms in the Ernst & Young reform proposals go beyond that because they take a real pluralist approach, saying that directors should just act for all the stakeholders and should not even have a first port of call being the members' interests. And those of you with long memories may remember back in Australia, following on from the James Hardie scandal in 2006, Australia considered adopting a provision like Section 172 of the UK Act, and it was considered by the Parliamentary Joint Committee on Corporations and Financial Services and CAMAC as it then was, and was rejected in the Australian context. A third development is occurring in the US, and this occurred in 2019 when the influential US Business Roundtable, which had traditionally been seen as the archetypal shareholder-centred body, said it had got it all wrong, and that going forward, the new purpose of US corporations would be to benefit all stakeholders and not just to act in the financial interests of the shareholders. Institutional investors, major institutional investors, such as BlackRock, have taken a similar approach. So even the shareholders today want companies to act, it seems, in the interests of stakeholders. The CEO of BlackRock back in 2019, Larry Fink, said this. He said that US corporations today must benefit all their stakeholders, including shareholders, employees, customers, and the communities in which they operate. And those kinds of messages are also finding their way into corporate governance codes and shareholder stewardship codes around the world. The UK, for example, updated its shareholder stewardship code in 2020, and there is a huge emphasis placed now on ESG matters and on environmental factors such as climate change in the new 2020 stewardship code. So I think that's an important shift that's going on around the world. How does it affect enforcement? I mean, to what extent are we now going to see directors sued for, these ESG matters and corporate integrity matters that Professor Bradney many decades ago said was another possible role for directors? Well, back in 1959, Justice Menzies of the Australian High Court, writing extracurricularly, said this. He said, what is expected of directors will tend to become the measure of what is required of them. And so my next question is, to what extent in the enforcement of directors' duties realm are we shifting towards, these different expectations of directors bubbling up in the enforcement realm? In other words, if law is always playing catch up to community expectations, to what extent can we expect the enforcement law to catch up in this regard? So many scholars are actually quite critical of the developments that I've just talked to you about, the Ernst & Young report and the Business Roundtable stakeholder approach in the US. Why are they critical? They're critical because they think it undermines director accountability. They think it means that because directors are beholden to so many groups, they will be accountable in terms of legal liability to none. And Professor Randall Thomas from Vanderbilt recently gave a talk in the Law and Business program at Monash Law School, and he said this is just managerialism re-emerging. This is what we don't want in terms of corporate law and accountability. So how do the enforcement regimes compare, for example, in the US, the UK and Australia in terms of directors' duties? Well, they're quite different. And let me just very briefly tell you why they're quite different. And I think they're quite different as a result, partly structural, partly doctrinal, and partly procedural reasons. The structural hurdle is basically what Dr. Higgins was talking about in relation to the Tesco case. It's very difficult in the corporate criminal area to hold directors and officers liable if they don't know what is going on bubbling at lower levels of the organisation. They, will lack that mental element that is normally a critical element of criminal law. And Professors John Coffey from Columbia University and Sam Buell from Duke University have both pointed out that there is this structural schism in large modern public companies between the upper level strategy type decision making and the lower level operational control. And that makes criminal liability against senior officers and directors very difficult. Well, to what extent can directors' duties, civil liability, fill that accountability or that responsibility gap? And in the US, it's very difficult to do that historically because of a doctrinal problem. Historically, a decision in the US in the 1990s in Delaware, the most important of the corporate law regimes in the US, there was a case, the Caremark decision, which basically provides directors with protection of the business judgment rule in the US for any oversight, even if it is grossly negligent, so long as the directors did not have actual knowledge and breach their duty of loyalty. So breach of duty of care, even when it's gross negligence, will not trigger liability under the US regime at all. Now, interestingly, however, a couple of years ago, there were two decisions in the Delaware Supreme Court which adopted a slightly less favourable approach to directors, and they were judgments of then Chancellor Leo Strine. And he suggested that even if the directors have no actual knowledge of misconduct within the company, they may breach their duty of oversight in the US where they have set up incentives in the organisation such that the whole business strategy is to inflate profits by creating problems, by, for example, circumventing environmental laws, by, for example, flouting health and food safety laws. And so I'd be interested, you know, Justice Bromwich was talking about recommendation 8 in the ALRC final report on corporate criminal responsibility. And I'd be interested whether in the, of course, they're looking in the criminal context there, but whether that's the kind of repeat player type liability that they are looking at there. The UK has hardly ever had duty of care cases, and it's been said there's an accountability firewall in the UK. Hardly any cases brought against directors in the aftermath of the global financial crisis. And the reason for that is the UK has basically a private enforcement regime, and private individuals, shareholders and companies have not really availed themselves of that. And they haven't availed themselves of it because of procedural hurdles, such as, until recently, the absence of class actions, loser pays litigation, and a range of other enforcement, private enforcement disincentives under the statutory derivative action. This may all be about to change with the introduction in the UK of the senior managers and certification regime, on which Australia's FAR and BEAR were partly based, but it's too soon to tell what's going to happen in that regard. The Australian regime is totally different to both the UK and the US. Although the Banking Royal Commission was concerned that ASIC did not bring a sufficient number of cases, the reality is that company directors in Australia face far greater risk of being found liable for breach of directors' duties than in the UK, where it's virtually zero, and in the US, where directors will usually be protected by the business judgment rule. And a study done in 2015, an empirical study by Dr. Jennifer Varzali, found that the directors of Australian public companies faced in 2015 a 0.08% risk of being named as defendants in an action for breach of directors' duties. And she pointed out that almost all the breach of directors' duties cases relating to public companies, but not private companies, but the public company ones were almost always brought by ASIC, and they were predominantly actions for breach of duty of care. So I think there is no doubt that in Australia there is much greater potential for directors to be liable for breach of duty of care and oversight failure, including in a broader range of matters, sometimes involving non-financial risks. And I think that was clear from the two memoranda written by Noel Hutley, Senior Counsel, and Sebastian Hartford-Davis, when they talked in those reports about the potential liability of Australian directors for disregarding risks associated with climate change. Public enforcement's getting a lot of attention in Europe at the moment as a way of solving the problem of too few cases being brought and too little accountability. So it'll be interesting to see whether the law in practice ultimately follows the changing societal expectations of directors. Thanks very much.